May it please the Court, my name is Barnwell, B-A-R-N-E-W-A-L-L, initials R-G, counsel for the defendant, Katie and Louise Enterprises, trading as a Young Chic line of retail stores, and I'm instructed by Brown and Associates. In response to Mr Marinak's submissions on behalf of the plaintiff seeking an action for breach of contract, I reject this claim. I make the following submissions proving my client's right to terminate the contract entered into with Bling Enterprises on the grounds of frustration and repudiation by implication and conduct. When entering into the contract, Bling Enterprises were well aware that an implied condition of the contract was time. Time was of the essence. They had full knowledge that they were retained to provide 3 shipments of jewellery prior to the jewellery being released to the Australian market, so as to ensure my client gained a competitive edge against my client's competitors by producing these products for sale in Australia prior to being released to any other store. I draw your Honour's attention to Cadelpha Constructions and the State Rail Authority of New South Wales. That was a High Court decision that was handed down in 1982, reported in volume 149 of the Commonwealth Law Reports, commencing on page 337. This case sets out the precedent for a frustrated contract. I set out the grounds of a frustrated contract pertaining to the second shipment of jewellery as follows, which you will note satisfy the requirements of Cadelpha and the State Rail Authority. The wharf strike in Brisbane, which resulted in delay of the jewellery, was due to no fault of either party. The obligations to have the jewellery ready for production to sell within my client's Australian store has not been able to be performed, and thus the circumstances have rendered the performance radically different. The same set of circumstances apply to the Cadelpha case, which resulted in the High Court determining that the contract had been frustrated, and as such, the same can be applied to my client. So far as the third shipment of jewellery is concerned, my client wishes to terminate the contract on the grounds of repudiation due to conduct. I draw your Honour's attention to the precedent set out in the case of Foreign and Wright. That was a High Court case handed down in 1989, reported in volume 168 of the Commonwealth Law Reports, commencing on page 385. This was a case of repudiation whereby the vendor was unable to supply a fair title to a property. Your Honour, the same set of circumstances can be drawn between the foreign case and my client. It was due to Bling Enterprises' inability to provide my client with the third shipment of jewellery in the manufacturing plant that resulted in my client losing the competitive advantage in the market, which was the sole objective of this contract. Bling Enterprises are arguing that payment should be made for the second and third batch of jewellery. In fact, Mr Marinak has acknowledged that his client had not met its obligations under the contract by Bling Enterprises offering my client a reduced amount with respect to the second and third shipments of jewellery. Whilst it had been agreed between the parties that the Australian consumer guarantees as to the quality and fitness for the purpose of the jewellery items were struck out, it did still, however, have an obligation to supply a product that could actually be worn for the purposes of jewellery. Accordingly, my client wishes to terminate this contract on the grounds of repudiation by implication. I draw your Honour's attention to the case of Hamo and Burrow and Coca-Cola. This was reported in the New Zealand Law Reports of 1962 at page 723. I assert that this case proves that Bling Enterprises did not meet their obligations to supply the agreed product that was understood to be jewellery that was to be worn. As decided in the Hamo and Burrow case, my client's contract was breached by Bling Enterprises due to repudiation. A fair conclusion could be drawn that the payment of the $10,000 for the first batch of jewellery should now be seen as full and final satisfaction of all 3 shipments of jewellery, and therefore satisfies the contract. With respect, Your Honour, none of the causes of action which might be raised from the plaintiff's submissions can be supported by facts before the court. It is my submission that the application must fail entirely, and in those circumstances my client respectively seeks the costs of this action to be borne by the plaintiff. Unless I may assist Your Honour further, those are my submissions.